Hello, everyone. My name is Daniel Landsman. I am the Director of Federal Legislative Affairs for FAMM, and I'm joined today by Mary Price, the General Counsel here at FAMM. And, you know, we're now 5 months out, about 5 months out from the enactment of the First Step Act. As you all know, President Trump signed the bill into law on December 21st. And we wanted to come here on Facebook Live and give you all an update where we are in terms of implementation, what parts of the bill are still outstanding, and, you know, answer any questions you guys have. I'll give a quick update on sort of broad strokes where we are. On the sentencing side, those reforms are already in place. As far as Fair Sentencing Act retroactivity goes, those have been sort of running along pretty smoothly. We have 643 people who have been released early and are now free from their sentences under FSA retro, and 826 total have had their sentences reduced, though some did not have it reduced to the point that they could be released from prison right away. On the prison reform side, after about a 4-month delay, the Department of Justice has named a host organization for the Independent Review Council. And for those that need a refresher, the IRC is going to work alongside the DOJ, establishing the risk and needs assessment, which is crucial to earn time credit created under the First Step Act. It goes in the Hudson Institute. And I will say that there are some concerns with the Hudson Institute relates to their experience in this field. They have not weighed in very often in the past as it relates to risk assessment. They don't have a strong background on the issue as far as many can tell. And this has already been noted by members of Congress. Last week, Chairman Jerry Nadler of the Judiciary Committee and Chair Karen Bass of the Crime and Terrorism Subcommittee put out a release statement asking the Department of Justice to rescind the invitation from the Hudson Institute. And in a nominee hearing for a Deputy Assistant General position, both Senator Lee and Senator Durbin voiced their concerns and displeasure with the choice of Hudson Institute along the lines of their lack of experience in this field. So we will see what happens. We will keep you all up to date as this process gets underway and we learn a little bit more about the risk and needs assessment. But now I'll turn it over to Mary to talk about compassionate release.
Thank you so much. And compassionate release is up and running as well. I'm happy to say this was not always the case. Over the years, those of you who have been with FAMM for a while know that for many years, the Bureau of Prisons was very, very stingy about promoting compassionate release and providing that access to prisoners. The way Congress set it up, only the Bureau of Prisons could ask a sentencing court to reduce an individual's sentence when they were dying or very, very sick or very old and had served a long time of their sentence. So that changed radically in December. Prior to that, only the Bureau of Prisons had the right to ask the court. But in December, Congress gave that right back to prisoners. And so individuals who have been denied compassionate release by the Bureau of Prisons or who have waited to hear back from the Bureau of Prisons about whether or not they're going to get compassionate release, now have the opportunity to go directly to court and ask the court either to appeal a denial or to ask the court to consider them for compassionate release in the first instance. So we're terrifically excited about this, and we know that there's a great deal of need out there because over the years we've been hearing from many, many prisoners and their loved ones to whom we've had to say, we're sorry, we can't help you because the Bureau of Prisons was the last stop on that road. So that has really changed, and in response to that, we set up a compassionate release clearinghouse, and we want to hear from prisoners who think they might benefit from compassionate release, and we're working with lawyers to represent them pro bono or for free to help them in court. So we can talk more about the parameters of compassionate release, and I'd love to see your questions about it, but we are definitely up and running. I think the report from the Department of Justice is at 22?
Yes,
I believe 22 prisoners have received compassionate release, which is not a big number, but we expect that to change. I know of a number of cases currently in the pipeline. So I think I'll stop there and look for your questions. And
Okay, so the first question is the million-dollar question. When will the 7-day good time adjustment be added to release dates, and when will inmates start getting it? So quick background for those unfamiliar with the issue at hand. As part of the First Step Act, Congress clarified their intent related to good time credits that it should count for 54 days of good time added to an individual sentence per year. Currently, based on how they interpret based on how the BOP interprets the statute, folks are only getting 47 days. The intent for this provision in the First Step Act was to be retroactive and to go into effect immediately. Unfortunately, there was a drafting error in the bill that has tied the implementation of the Goodtime fix to the release of the risk and needs assessment, which are two unrelated issues, but they put it in the same section that had to do with earned time credits, which I can explain the difference later on. So the point being is the DOJ has taken the stance based on the statute at hand that they are not able to begin recalculating those until the risk and needs assessment is released. Under the First Step Act, the DOJ has to release that risk and needs assessment 210 days after enactment, which should be around July 19th. Of course, with the delay in announcing the IRC host organization and the shutdown, we're not sure what exactly is going to happen. FAMM has sent a letter to the DOJ asking to clarify when exactly they're going to put in the Goodtime recalculations. Representative Cedric Richmond has sent his own letter asking the same question, and Chairman Nadler of the Judiciary Committee sent a sign-on letter signed by several other members of his committee asking, amongst other questions, when they plan to do the recalculations and urging them to use their discretion at BOP to recalculate. Now, FAMM's position has had a long-standing position that Congress needs to fix this in order to get it implemented immediately. And we have announced publicly that we are calling on Congress to do that. We have an action alert on our website. Of course, we are getting closer to that July date, so hopefully we'll start seeing stuff soon. But for the time being, we are just monitoring it very closely, very actively. We're keeping in close contact with folks on the Hill to see what they're hearing, what they're thinking. And as soon as we have something more concrete to tell you, you all will be the first to know. But for the time being, we'll be monitoring it closely and hoping for some resolutions shortly.
We get to say we're cautiously optimistic.
Yeah, cautiously optimistic that something will happen soon, but please stay tuned for more.
And just for those of you who've just joined us, I'm Mary Price. I'm the General Counsel for FAMM, and this is Daniel Landsman, and he is?
I'm the Director of Federal Legislative Affairs for FAMM. So I'm the one who goes to the Hill and talks to all the members about you all's needs and questions. And for those just joining, we're just doing an overview on implementation of the First Step Act and trying to respond as many questions as we can over the next hour or so. And we'll go on to the next question here from Tammy. Do you need an attorney to start the process of the First Step Act regarding Goodtime, or does BOP automatically deduct for those who qualify? You could take.
I'm absolutely. That's a very good question, and it is an automatic deduction. It is statutory. It means that every single person, besides people who are serving a sentence of life in prison, get the additional 7 days per year, and it will be applied to them retroactively. So once it's applied, you will see it on, if you go to the BOP inmate locator and look at your loved one's sentence, that sentence date will actually change. So you might want to take a snapshot of it now and compare because it will change eventually, and it is automatic and there's no application necessary.
So if anyone is offering you services to get the Goodtime, not necessary. It's an automatic deduction.
Exactly. Please don't pay somebody to do that. Or call us first. You can always call us. Our phone number is 202-822-6700, and there are people standing by who want to hear from you and share information and answer questions. And if we don't know the answers, we'll get them for you.
And of course, you can always ask in Families in Action as well.
Exactly.
Next question. What should federal public defenders know about the First Step Act? They should know pretty intimately the details of it by now. Mary can give more information, but I know that they've been having trainings on the bill, in their more localized trainings, as well as some more national webinars and things like that. And so the attorneys there should be pretty well versed, especially on the sentencing side, but even on the prison reform side, on the contents of it.
Oh, right, of course. Yeah. So going forward, of course, everybody will be arguing for the new lower sentences under the law. The Fair Sentencing Act retroactivity, crack retroactivity, the federal public defenders have been trained in that, and every office that I've talked to, and I talked to a number of them for compassionate release, has one or more attorneys assigned specifically just to do First Step Act crack retroactivity cases. And they're very good, and they're filing motions and working with probation and with the government to sometimes get consent motions. So that's all going forward. So they are pretty well versed. They're often my first go-to when I have a question about those things. They are also handling, in many, many cases, compassionate release cases. So when I get a referral through our clearinghouse, one of the first places I go is to the First Step Act attorney in the Federal Public Defender's Office to say, hey, are you doing these cases? And if so, can I refer a case to you? And frequently they say yes, and take them on and get good results.
So this next question is from Leslie. Why are some of these federal district judges not resentencing people that are eligible? Mary, would you like to? And that's as far as Fair Sentencing Act is concerned.
As far as the Fair Sentencing Act is concerned, I don't know. The crack retroactivity is a brand new thing. We've never seen anything like it before in federal law. It's not like those of you who may be familiar with drugs -2 or crack -2 or Fair Sentencing Act guideline retroactivity. Those were relatively straightforward. I mean, lists had to be gathered and so forth, but really all the individual judge had to do is, if they agreed, was to reduce somebody's sentence by 2 guideline levels, and there was nothing else to look at. This is very different because this is a whole new resentencing. And so attorneys are going to be coming in, good attorneys will come in and argue not just for a change to what the sentence would have been imposed back in the day, but they're going to be talking about how the person has improved in prison and are ready to really take the next step and leave. They're going to be talking about variances and departures and all the kinds of things that happen in sentencing. So it took a little minute, I think, for the administrative office of the courts to get up on sort of guidance to judges about how to do this, and for defenders and probation officers and to some extent U.S. attorneys to identify individuals who actually might qualify for this, and then for guidance and briefings and all kinds of things. So it's been a rather longer process. Judges presumably are looking at these as individuals and taking these very seriously. Some judges move more quickly than others. So we don't know that we certainly don't think that there's any resistance to doing these overall, because we'd be seeing a lot of denials, but in fact that's not the case. So I think that judges are just taking their time, and some districts may be slower than others. We have heard that, yeah. But we don't have any concern that there's some kind of resistance going on out there.
And there's a follow-up question here. Why are some recalculating and releasing, that's federal judges, and other districts are requiring certificates of achievements, etc.? That is not an issue that I've heard come up.
Right. Judges, when they're doing these motions, have to look at the entire individual, and they have to look at their conduct in prison. They want to understand whether or not this person has, in fact, been, I don't want to say a model prisoner, but they haven't misbehaved in ways and so forth. So I think probably some of that is just looking at, how has this person comported themselves while they're incarcerated. Because when they do a resentencing motion like this, they have to consider what they call the 3553A factor. Some of you have heard me say this before, and it's a pretty specific look at a variety of different things about the individual, about the crime, and about their progress while they're in prison and rehabilitation. So I expect that that's why. And again, judges are different. They're going to handle these cases and these resentencings differently. Bet asks, hello Bet, more information about elderly release and compassionate release.
Also, what about the within 500 miles upon bed availability going to be enforced? So we've talked a little bit about compassionate release already. We can touch on the elderly pilot program. So for folks who are unaware, prior to the First Step Act, I believe in fiscal year 2016, there was a pilot program in one BOP facility that allowed the BOP to place elderly prisoners who were above the ages of 65, who had served either 66% of their, or 75% of their sentence, or had served 10 years, could be placed on home confinement for the remainder of their sentence. The First Step Act reauthorizes that pilot program for fiscal years 2019 through 2023. And it has expanded it to multiple BOP facilities. The BOP did put out a operations guideline on this, which restates many of the points from the bill, such as the new requirements that allow home confinement for individuals who are 60 years and have served 2/3 of their sentence. It does away with the or 10 years. And it also adds terminally ill individuals, which is defined as someone who needs around-the-clock care in like a nursing facility or assisted living facility, or is terminally ill. Can also be allowed into home confinement. The statute does open it up to more than one BOP facility. However, which facilities are at the discretion of the BOP, and those have not been announced yet, though we are cautiously optimistic that it will be in all the facilities, and that was certainly the intent of many of the advocates who are pushing for this, and we certainly hope that will be the case. Unless you have anything.
Yeah, just the interplay between the elderly pilot program or the terminally ill pilot program and compassionate release. What's happening, what the Bureau of Prisons has said in its guidance to wardens is, particularly if you have a prisoner who is terminally ill, the first thing to consider is whether or not to recommend them for compassionate release rather than put them into this other program. The elderly pilot program has a lot of restrictions with respect to the crime for which you've been incarcerated or prior crimes. So people with histories of violence or certain kinds of offenses can't be considered, nor can people who are serving a life sentence. None of those restrictions apply with respect to compassionate release. So it's always the better first step to go to that. The other thing is that, to distinguish the two, is that the elderly program is completely at the discretion, elderly pilot program, is it completely at the discretion of the Bureau of Prisons. It's not a thing that you can do in court, whereas compassionate release is initially at the discretion of the Bureau of Prisons, and they can decide to bring a motion, and if not, as I explained earlier, one can get a lawyer or one can file a motion in front of the sentencing judge to say, look, it's time for me to get compassionate release. That's not the case with the elderly program.
And just to touch on the 500-mile rule very quickly, little background: prior to the First Step Act, the BOP had a policy to, when possible, have people housed within 500 miles as the crow flies to their families. The First Step Act makes that driving miles, because under the 500-mile rule, previously that could end up being 600, 800 miles when taking into account driving directions, which could put people out of touch with their families and just unable to have visits. More importantly, or more exciting aspect of the rule is they now have a charge to bring people even closer if they're in 500 miles, if a bed opens up, to bring them even closer. We haven't had a policy statement on that yet, and I have not heard of anyone who has gotten it. We hope a policy statement's coming. That was in the letter that Chairman Nadler sent to the Department of Justice, asking, how they were planning to implement this provision. I will say a lot of this is going to become more clear if and when the House Judiciary or House Oversight or Senate Judiciary Committee, for that matter, can get the Bureau of Prisons in and conduct an oversight hearing. And until then, we'll continue to monitor the situation closely. I do want to go back, Lonnie, if possible, to a question that was above that we didn't get a chance to answer, which is an important one because I missed it. Yeah, there you go. Diana asks, will all elderly offenders receive home confinement if they meet the criteria and time constraint, or will it be limited to certain locations and/or security levels, or decided on a case-by-case basis? So the answer to this is likely going to be case-by-case basis.
It's sort of yes, I think. So you have to be eligible. So it means you can't be convicted of certain crimes. You have to have the age and the time served requirement. You can't have be serving on a sentence of life. We don't know about the certain locations. We're hoping that it's across the board, and I think they hope that it's across the board as well. But they will be decided on a case-by-case basis because they have to make an individualized determination about whether placing somebody on home confinement, saves the money basically, and also if there's any risk to the community. So they're going to be taking a careful look at that. And I think, that it's going to be, a pretty individualized consideration.
Yes. Yeah. What imagine so. Okay. Thank you, Lonnie. Okay. So Ree asks, why are prisoners who are eligible for the Second Chance Act not being processed? So this is a question related to the Second Chance Act, which was passed in 2007. I believe this is what Ree's asking. that allowed prisoners to have up to 12 months in the halfway house prior to completing their sentence. And this has always been something that's up to the discretion of the BOP. It doesn't force the BOP. It doesn't compel the BOP to put folks in halfway house for 12 months. It just allows them to go up to the 12-month mark. Very rarely do people get the 12 months. Already people are seeing their halfway house time cut. And so, you know, there's a lot in the First Step Act to prioritize and incentivize more time on pre-release custody, especially when considering home confinement. But we are going to have to keep a really close look on pre-release custody, especially people going to halfway house time, because there's already some issue with BOP not sending people for their full time eligible or the amount requested or even the amount recommended. And as people get these earned time credits, which are redeemable for more than a year in halfway house time, then, you know, we're going to have to really keep an eye on sort of capacity issues.
Cassie asks a great question. If the Goodtime mistake was just an error, why don't they fix it? And it's our question too.
Yeah, that's our question too. You know, obviously politics will always play a role in any legislation going into Congress. I think the House could pass it in a week, and then it would go and sort of stall in the Senate. The same sort of concerns with getting criminal justice reform onto the floor are still very real, especially for an individual standalone bill. There are still people who don't like this issue. And I think just the politics, especially in the Senate, are just a bit too daunting for some folks in Congress. So we'll see. Michelle asks, when do you expect the Bureau of Prisons to announce elderly release locations?
You know, the way I read this, I think it's going to everybody.
Yeah.
I mean, I don't know that they're going to have to. I mean, they have these, there's a regulation, an operations memorandum that went to all the prisons, and it says, you know, it basically speaks to all the local facilities. So I'm not sure that they're going to limit it to anybody.
Does the 2/3 sentence serve take the 85% good time into consideration? It does not.
It does not. It's 2/3 of the sentence that was imposed.
Yeah.
So if you are sentenced to 10 years, it's 2/3 of 10 years.
Next question. How do judges now have the discretion to sentence defendants under mandatory minimums? That's a good question. So there were 4 sentencing reform provisions in the First Step Act. One was Fair Sentencing Act retroactivity, which, as we have discussed, allows judges the opportunity to resentence individuals to a much shorter sentence and possibly time served, based on, you know, a number of factors that we as an organization would love for a judge to be able to consider at sentencing in the first place. 2 of the sentencing reform provisions do not really allow more discretion at sentencing. That would be the 924C, which sort of changes the way stacking can be done. Prior to the First Step Act, an individual could get a sentence for a first-time offense and second subsequent offense during one proceeding, and that doesn't make any sense. And so they got rid of that, but judges are still going to be have their hands tied when dealing with 924C, and will have to give the 5-year mandatory minimum on a first offense. The second one has to do with the 841, 851 enhancements for second and subsequent drug offenders. Again, not much discretion given back to the judges there. Instead, we moved life for a third drug offense down to 25 years and 20 years for a second drug offense down to 15 years. Where judges' discretion was increased a little bit is under the safety valve. Prior to the First Step Act, you were not eligible for the safety valve if you had more than 1 criminal history point.
Mm-hmm.
That has been expanded to 4 criminal history points, while excluding a 2-point violent crime or any 3-point offense. So if one offense gives you 2 points or 3 points as your base, you're excluded. But other than that, you can have up to 4 criminal history points. And so in that regard, it does expand the safety valve to allow the judges to use it a little more freely and a little more often. I'm sorry?
Only for drug
Only for drug offenses, of course. So sort of in the regard of getting discretion back to the judges, this was the First Step Act, and we do have many more steps to go. And we'll hopefully have some exciting stuff to talk about that soon, and as far as sort of where we see sentencing going in the future. But yeah, so not much discretion given back to the judges, unfortunately.
Well, I had one thing, which is with respect to the 2 and 3 strike sentences. They used to just be applied to people who had prior drug offenses. And now a little bit more discretion has been taken away from the judge, because even though the sentences for those have been shortened, the judges or the prosecutors can now use prior crimes of violence as what they call predicates or qualifiers. So unfortunately, more people will be potentially drawn into 2 and 3 strike sentences than were before. Should we say who we are?
Yes, sure.
First.
For folks who missed the beginning of this video, of this Facebook Live, my name is Daniel Landsman. I'm the Director of Federal Legislative Affairs here at FAMM. So I go up to the Hill and talk with members of Congress about you all's concerns and wants as far as sentencing and criminal justice reform is concerned. And I'm joined today by Mary Price, who is our General Counsel here at FAMM. And we are just doing a video here talking about the implementation of the First Step Act, which passed back in December and was signed into law by the President on December 21st. We have a question here from Colleen. Can you confirm a post in the FAMM Facebook group yesterday that the retroactive Goodtime is currently being factored at least at one federal prison? We cannot confirm that. Yeah.
We saw that. We're keeping an eye out.
Yeah.
We're monitoring. Everybody takes snapshot, as I said. Go into your to the BOP inmate locator and take a snapshot of the time and there and see. Yeah. We hope it changes soon. They must be beginning the recalculation, but we can't confirm that.
Okay.
We're finished?
Yeah. So that's all the questions we have today. It's been a pleasure talking with you all today. I just want to remind everyone to join FAMM. If you go to our website, famm.org, and the Justice Action Now Center, there's a link to join FAMM and start getting engaged on these issues. You can also, if you're directly impacted, if you have a loved one in prison, a friend in prison, you can join our Families in Action page on Facebook. That's FAMM. ILIES in action on Facebook. Follow us on Twitter at FAMM Foundation. Follow me on Twitter at Dan_Landsman, and Mary Price at Mary from FAMM.
And there's also for those of you whose loved ones are going through the compassionate release process in prison, you can also join a special Facebook page for compassionate release. It's a private page, and we keep lawyers off of it and anybody else off of it, but it's just a support section for us. We can answer your questions and hear from you and learn about cases. So, and again, I want to make a pitch. If you know somebody who is in prison who may qualify for compassionate release, let us know. Reach out to us at stories@famm.org, and we will get back to you.
Yeah.
Thank you so much.
And thank you so much for your questions, and continue to post in the Facebook. We monitor that, and we'll always be helpful to answer questions. And like Mary said, if you have a question, give us a call here at FAMM, 202-822-6700. Lovely. Thank you all.
Thank you.